Welcome back, everybody, to another episode of the Law with Darren podcast. And today I'll be covering a fairly brand new decision by the Rhode Island Supreme Court of a case where a gentleman named Michael Meeks, went to a local Stop and Shop back in 2016 and ordered some cod, and apparently was not aware that while his cod was being prepared, I guess the Stop and Shop workers also were handling some salmon at the same time, and he believed that there was some cross-contamination between salmon and his cod order. So, what happened exactly? Well, according to his testimony in that case, on June 7, 2016, the plaintiff handed a Stop and Shop seafood clerk a piece of paper that constituted his fish order, which order called for packages of cod and tuna. He testified that after leaving the paper containing his fish order with the clerk, he continued doing his shopping and later returned to the seafood counter to pick up his order. The plaintiff stated that when he initially handed the clerk the piece of paper, he noticed that the clerk was cutting salmon on a cutting board with a knife and that the clerk was wearing gloves. He further testified that upon returning home after shopping, he proceeded to prepare some of the fish that he had just purchased. He stated that within 20 minutes of starting to eat the fish, he began to have an allergic reaction. His skin began turning red, and he was heating up. Knowing full well what was going to happen next, and with his throat beginning to close, the plaintiff called for a rescue and was immediately taken to the hospital. Significantly, though, what's interesting about this case is that the plaintiff in this case, a gentleman named Michael Meeks, never informed the employees at Stop and Shop that he was in fact allergic to salmon. So he goes to Stop and Shop, goes to the seafood department, puts an order in for some cod and some tuna, and they're preparing salmon. He sees them working with salmon, and then he walks away. So he never actually sees any Stop and Shop employee handling salmon and then handling his cod and tuna order. But again, he never told the employees there that he was allergic to salmon. So what happens? Well, he sues Stop and Shop, claiming that they were negligent and in violation of some state and federal regulations regarding the cross-contamination of fish, namely salmon, cod, and tuna. But there was a problem with this case because the lawyers for Stop and Shop essentially asked the court after a few years of litigation to say, hey, Your Honor, we're not aware of any regulations, state or federal, that the plaintiff has produced that showed that we had any duty to not have any cross-contamination, which we deny in the first place, as of course they would, and that therefore the plaintiff cannot win this case because there's simply no basis for a lawsuit here. There's nothing for a jury to listen to. So the lawyers for Stop and Shop filed what is known as a motion for summary judgment, basically asking the judge to say, Your Honor, there's no case here. Let's all go home. They had the hearing, and the hearing judge agrees and dismisses the case against Stop and Shop. So their lawyers did a good job in this one, recognized the critical flaw in the plaintiff's case, and dismissed the case. The plaintiff, undeterred, filed an appeal and went before the Rhode Island Supreme Court, basically to argue his initial point, or his argument, that Stop and Shop failed to adhere to regulations concerning cross-contamination between salmon and tuna and cod, and referencing some state and federal regulations that apparently he couldn't find because at the hearing, the plaintiff's attorney still had not produced any such regulations. So there was nothing for the judge to really put their teeth into to say, oh, well, maybe the plaintiff is right. Maybe Stop and Shop did make a mistake. So ultimately, the Rhode Island Supreme Court agrees with the lower court and upholds and dismisses the appeal as well. So the plaintiff in this case loses. But what's interesting, and there's a few lessons to be taken from this case, ladies and gentlemen. The first one is if you're an attorney, you definitely need to make sure that you actually find the regulations that you're talking about. You can't just say that, oh, there are regulations that exist and then not cite them. That's not a good idea because, if someone calls you bluff, like the judge or the opposing counsel, you're going to lose. But two, the Rhode Island Supreme Court really seems to bite into the fact that the plaintiff never indicated in this case or disclosed to Stop and Shop that he was in fact allergic to salmon. Now, the appeals courts don't like saying things for no reason because it gives people like me a chance to look at cases and say, well, wait a minute, what are they saying here? Why would they say that if they didn't think it was important? What do they want us to think about here? And honestly, in the case like this, I think that what the Rhode Island Supreme Court is hinting at is that even if there is no state or federal regulation concerning cross-contamination procedures of salmon and cod and tuna at a seafood grocery clerk, if you disclose to them that you are allergic and you do put a request in that they, use different sterilized or sanitized equipment to cut your fish, that might be enough. If they fail to do so and you are in fact, you do suffer an allergic reaction. So again, that's what I took from this case. For those of you that are curious, if you want to look it up online, you can. The citation is Rhode Island Supreme Court 2021-276. That's the Rhode Island Supreme Court citation. You feel free to look that up. You can go right to the Supreme Court's website. So at the end of the day, lesson learned here, people. If you have an allergy, you need to tell everybody. Tell, the grocery store, the restaurant, whoever you're working with. Remind them that you have an allergy. Actually, don't remind them. Just tell them for the first time that you have an allergy. Because if you don't, and you assume that there's some sort of policy or guidelines that they must follow as a restaurant or grocery store, and you're wrong, there might not be a basis for you to sue to say that they harmed you because they failed to protect you. They failed to honor their duty to make sure that there was no cross-contamination between possible allergic foods. So that's the lesson here, guys. Hope you guys enjoyed it. Have a good day. Be well. Stay safe.